First question, consider the following statements. Question number 1, consider the following statements. Pursuant to the report of H.N. Sanyal Committee, Contempt of Court Act 1971 was passed. Okay. Constitution of India empowers the Supreme Court and High Court to punish for contempt of themselves. Constitution of India defines civil contempt, criminal contempt. And statement 4, in India, Parliament is vested with the powers to make laws on contempt of court. ಈ ತರ statements ಇದ್ದಾಗ first we'll try to identify the things which we know. What is that we know? We know that Constitution of India empowers the Supreme Court and the High Court to punish for contempt of court. Article 129 for Supreme Court and Article 215 for High Court. Constitution has given this power for only Supreme Court and High Court. See, subordinate courts, they are not empowered to take action on contempt. Only the Supreme and the High Court can. So, idu correct annadu gottu. So, that means C is eliminated, D is eliminated, A or B. So, statement 1 ಬಗ್ಗೆ ನಮಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ, but from these options we get to know that statement 1 is correct. Look at the third statement. Constitution of India defines. We have spoken earlier also, whenever the term Constitution of India comes, most of the time UPSC has made the statement as wrong. It is telling Constitution of India defines civil and criminal contempt. Constitution of India does not define it. It only mentions. It is defined in Contempt of Court Act 1971. So 3 wrong. Anyway, it was not needed. In India, Parliament is vested with the powers to make laws on contempt of court. This is correct. See, Parliament is vested with the power to make law on any subject. Itara kottang mostly correct irate because Parliament has very broad range of powers it has a very broad jurisdiction when it comes to making laws. So Parliament has the power to make law on so and so subject anta kottaga most of the cases alli it will be correct. So the answer to this question is 1, 2 and 4. So contempt of court, very important thing. Constitution only mentions about contempt of court. It does not define or give categorization as civil and criminal contempt. So contempt of court are 2 categories ide, civil contempt, criminal contempt. So what are each of these? All these things are defined in Contempt of Court Act 1971. Another important note that we need to make is H.N. Sanyal Committee was the committee which made recommendation on the basis of which Contempt of Court Act 1971 was formulated. So civil contempt antide, criminal contempt antide. A court gives a particular order and if the person does not follow it, then that will lead to civil contempt. But if a certain person, he obstructs the administration of justice, or if he tries to lower the respect of the courts, then that would fall under criminal contempt. And all these things are in detail dealt with Contempt of Court Act 1971, whereas Constitution just makes a brief mention about it. See, Contempt of Court Act, it acts as a restriction under Article 19(2). It acts as a restriction on freedom of speech because the rights of the constitutional rights under freedom of speech, it is not absolute. It is subjected to restrictions. So kinds of contempt of court, civil, criminal kuda ide, and Parliament is empowered to make the law, and this power has been given by the Constitution itself. And contempt of court articles 129 for Supreme Court and 215 for High Court. These are the basic things that we need to know, and also Constitution does not define, it only mentions.